This is cause number 23 CCCR 2098, case of style of state of Texas versus DeQuincy Emerson.
Yes,
Mr. Emerson, is that your full name?
sir.
How are you doing, Mr. Emerson? I'm doing fine, thanks for asking. Now, Mr. Emerson, I understand that you were next door in one of the other courts. And so you had missed the arraignment. And so what I'm going to do is go over the arraignment with you.
Yes, sir.
And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is classified as a Class A misdemeanor. It's assault, family violence, or an assault causing bodily injury, not family violence. Now, the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, or you could be given a fine from $0 to $4,000, or you can be given both such fine and confinement. Do you understand that?
Yes, sir.
Now, as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. Now, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. It has a signature here. Is this your signature?
Yes, sir.
And there's some initials on the line stating you'd like to apply for court-appointed attorney. And that's yours. Are these your initials?
Mhm.
Now, as a defendant in a criminal case, you should understand that you have 3 options. Number 1, you may hire an attorney. Number 2, you may request that an attorney be appointed to represent you if you do not have the financial ability to pay for an attorney. Or number 3, you may represent yourself. That is, you can waive or give up your right to representation by an attorney and represent yourself. Do you understand that?
Yes, sir.
Now, I know here from looking at this form that you signed, you're requesting a court-appointed attorney. Is that correct?
Yes, sir.
And now, before you signed and initialed these documents, you read the documents, you understood everything that you read, and everything in these documents are true and correct.
Yes, sir.
Okay. Now, as a defendant in a criminal case, you have a right to have a trial by jury. When those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence. They will listen to the arguments, and then they will decide after deliberating whether to find you not guilty or guilty of your charges. Do you understand that?
Yes, sir.
Now, you can waive or give up your right to have a trial by jury. And if you waive or give up your right to have a trial by jury, your case can come before the judge in one of 3 ways. One way it can come before the judge is by way of a trial. That's a trial without a jury. We call that a bench trial. It's a trial by judge only. Do you understand that?
Yes, sir.
The judge will listen to all of the evidence and the arguments, and then the judge will decide whether or not to find you not guilty or guilty. Now, you also have a right to enter into a plea bargain agreement with the state. What a plea bargain agreement is, it's an agreement to settle your case. And if you reach a plea bargain agreement, we call that an agreed plea bargain agreement. If you're unable to reach a plea bargain agreement and you still want your case to come before the judge, we call that an unagreed plea bargain agreement. I'll just tell you the difference between the two. Unagreed means that you and the state have not been able to reach an agreement, and you still want the judge to decide what your punishment is. Agreed plea bargain means that you and the state have reached an agreement, and if you and the state have reached an agreement, then your case will come before the judge, and the judge can do one of 2 things. The judge could accept the plea bargain agreement or reject the plea bargain agreement. Do you understand that? Now, if the judge accepts, no, if the judge rejects your plea bargain agreement, then you have the option to withdraw, which means to take back your plea bargain agreement. So, for example, let's say you and the state has worked out a plea bargain agreement. The state say, well, we're going to give him 1 day in jail. And he comes before the judge, and the judge said, well, I'm not going to follow that plea bargain agreement. Then if the judge does not follow the plea bargain agreement, you have a right to say, well, judge, I take back or I withdraw my plea bargain that I made with the state. Do you understand that?
Yes, sir.
Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days of the judge following the plea bargain agreement that you would like to appeal your case, that is, you would like to have a higher court to review your case to see whether or not you've been wrongfully convicted or we committed an error by convicting you. That's what you call an appeal. Then if you want to appeal your case, if the judge, after the judge has followed the plea bargain agreement, you have to get permission from the judge. Do you understand that?
Yes.
Now, if the judge gives you permission, then your case is going to be appealed. It's going to leave this court and go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case. They could either grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. Do you understand that?
Yes, sir.
Now, if they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, and that court is the Texas Court of Criminal Appeals located in Austin, Texas. You will have to file what is called a pro se petition for discretionary review. Pro se means you'll be representing yourself. You won't have a lawyer, and you'll be asking them to review your case to see whether or not your appeal should have been granted, whether or not we wrongfully convicted you, or whether or not we committed an error by convicting you. Do you understand that?
Yes, sir.
Now, they can do one of two things. They could grant or deny your pro se petition. If they grant your pro se petition, they can simply find you not guilty. Or they could send the court back to the Ninth Court of Appeals or send it back down to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Do you understand that?
Yes, sir.
All right. Now, you also have a right to have witnesses to come to court. If you have a trial, you have a right to call witnesses. They sit in that chair over there. We call that the witness stand. They can testify for you or against you. If you're representing yourself, you can ask them questions. If you have an attorney, your attorney could ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses, meaning that you don't have to call witnesses in your case. Now, if you do not call witnesses in your case, it does not mean that the state will not call witnesses, because they will be calling witnesses. You also have a right to have what is called discovery. Discovery means you have a right to see all of the evidence that the state will be using against you, all of the evidence that the state has against you. You have a right to see it. You have a right to see witness statements, your statements. You have a right to see police reports, lab reports. You have a right to review audio recordings, video recordings, and you have a right to see any instruments that they may have. Whatever evidence that they have, you have a right to see it. We call that discovery. Now, you can waive or give up your right as well. Do you understand that?
Yes, sir.
Okay. Now, you've been arrested and you're out of jail on bond, right? And do you have a bondsman?
Yes, sir.
Okay. Now, so you pay the bondsman a percentage of the bond to get out of jail. Now, every day that you spent in jail, and by the way, when I use the term day, if you spent 1 minute in jail and then you bonded out, that's considered a day. Now, every day that you spent in jail, that can be used as credit towards your punishment. So for example, let's say you spent 5 days in jail. And let's say you and the state district attorney has reached an agreement, a plea bargain agreement for you to serve 5 days in jail. What that means is you would not have to serve any more time in jail because the time that you spent in jail has already been served. Therefore, you'll be given credit for the time that you've already served. And so you'll be given credit for what we call time served. Do you understand that?
Mm-hmm.
Now, if the state is offering 7 days in jail, you spent 5 days in jail, that means that we'll take 5 from the 7, and that leaves 2. So you would have to serve 2 days in jail. Do you understand that?
Yes, sir.
Now, every day that you spent in jail also can be used as credit toward your fine and court costs. You will receive $100 per day, which will be credited toward your time and court costs. So, for example, if you spent 5 days in jail, that's $500. That can be used toward your fine and court costs. So if the state is offering you fine and court costs of $500, that means you don't have to pay nothing. Why? Because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. If they are offering fine and court costs of $700, that simply means that you will only have to pay $200 because you already have $500 credit. So we'll take 5 from the 700 and that leaves 200. Now, you'll be required to pay the fine on that day. If you are unable to pay the fine on that day, we can put you on what is called a payment plan. Now, even if we put you on a payment plan, if you tell a court, well, judge, I can't pay it off because I don't have an income, I don't have a job, and then if the court finds that you are indigent, the court can convert your fine and court costs to community service. And what that means is this: you will perform work at a nonprofit organization in Jefferson County, and for every 1 hour that you perform or work, $12.50 will go toward the payment of your fine and court costs. So if you work 8 hours, that's $100 that will go toward your fine and court costs. Do you understand that?
Mm-hmm.
Okay. Now, Jefferson County has a program that is called pretrial diversion. If you've never been in trouble before, and it's your first time getting in trouble, they have a program called pretrial diversion where they would dismiss the case. Okay. And if you successfully complete the program, you can get it expunged or wiped off your record like it never happened. In order to qualify for the program, you have to have a lawyer to assist you at getting in the program. It has to be your first time getting into trouble, and it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest, and that is not your offense. Now, this court has a program that is called the Community Safety Initiative. It's a program that started in March of 2017 within 100 days of taking office. As soon as I was elected, within 100 days, I started this program called the Community Safety Initiative, the CSI program. That program is designed to address the issue of recidivism. And what recidivism is, it means that people commit crimes over and over. And so the way we address it is through our CSI program. With that program, we have partnership with local agencies. One of the agencies that we have a partnership with is Spindletop Center. It's a local mental health center in the Jefferson County area or in the Southeast Texas region. And what they will do, they will perform a private interview. They can do an assessment, and they can develop a treatment plan for outpatient or inpatient treatment, depending on what your mental health needs are. Now, you do not have to be incompetent or insane to participate in the program. You could just simply suffer from anxiety or depression or any other host of mental illnesses. Okay. And what will happen if you get into the program, as I mentioned, they will do a private interview, do an assessment, and develop a treatment plan. If you have issues with drugs or alcohol, they have a program called ATAR. And with ATAR stands for Addiction, Treatment, and Recovery. And with that program, along with OZAR, which has a program, the OZAR is outreach, screening, and referral. Those two, or assessment and referral, those two programs are designed to help people who have issues with drugs and alcohol. Okay? The other thing, if you're not working, or if you're looking for a better job, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. What they will do is train you in the area that you select, and they will help you to get a job in the area that you're trained in. If you have not graduated from high school and you would like to get a GED, CICE has a GED program, Graduate Equivalency Diploma. You can receive that. Now, all of these programs are free. Does not cost you anything. Only thing it costs you is time. And I like to say in this court, we do not just give time, we take our time. And what that means is we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to tell people this: when you come to county court at law number 2, we don't have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And if we make a difference in their lives, we will make a difference in their home. And if we make a difference in their home, we will also make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. Now, the other thing about this program is that all of these programs could be used as community service. So let's say, for example, you were ordered to pay a fine. You couldn't pay the fine, we converted it to community service. And let's say you have issues with drugs and alcohol. While you are in counseling for 1 hour, $12.50 is going toward paying your fine and court costs. 1 hour is going toward paying, 1 hour will go towards your community service. Okay, so while you're in job training, the same thing. While you're being trained on a job, 1 hour, $12.50 will go towards your fine and court costs. 1 hour will go toward community service. Or while you're getting mental health treatment, mental health counseling, 1 hour, $12.50 will go toward your fine and court costs, and 1 hour will go toward your community service. So you're doing one thing, but you're getting credit for 3. You're getting credit for being in the program, you're getting credit for community service, and you're getting credit for paying your fine and court costs. Okay? So with these programs, as I mentioned, all of them are designed to produce productive people. And we're trying to make Jefferson County a safer place for all of us to live, work, go to school, and raise our children and go to church. So if you're interested in any one of these programs, just let us know, okay? Now, please raise your right hand. Your hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. I have before me these 2 documents that you have acknowledged. First document is judge's explanation of rights to defendants without attorney. And this is your signature on this document. Is that correct?
Yes, sir.
And these are your initials on the line that state you would like to apply for a court-appointed attorney. Is that
Yes,
correct?
sir.
I also have a document that is titled Jefferson County Affidavit of Energy. And is this your signature on the line that is titled defendant?
Yes, sir.
Now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Emerson, I read your answers. Based on your answers, you meet the eligibility requirements of a court-appointed attorney, and the attorney that will be appointed to represent you is Attorney Todd LeBlanc. Attorney LeBlanc will be given information to contact you, and you will also be given information to contact him. The court coordinator will give you that information. Once she gives you that information, you'll be free to leave. Now, Mr. Emerson, Ms. Moses, Mr. Emerson, did you get one of the forms from Spindletop? Did you get one of those? It was on the clipboard? I don't have that with me. Um, you can come back on up. I know a lot of times, your generation, you always talking about, you have your friends and your friends got your back, y'all see all of that stuff, right? And y'all put a lot of reliance, y'all rely a lot on the fact that y'all have friends and friendships. But I've been doing this a long time. I've been practicing law since 1990. Okay. I prosecuted, I defended people. I even taught law school, and I've been a judge, municipal court judge from 2009 to 2016. And I've been in this court since 2016 up until today. And the reason why I say that is because over the years, what I found out is a lot of times, young people say, "Oh, that's my boy. He got my back." But a lot of times when people get in trouble, I don't see their boys with them. They got your back. I'm looking behind you right now. I don't see your boys with you. But what I usually see is family members, right? Mom, dad, grandmom, everybody. That's the people that have your back. Okay. Because what I always tell young people, a lot of times, the person that put food on the table, roof over the head, clothes on your back, that's the person that have your back. Okay. So don't believe the hype. Okay. All right. They tell you they're gonna do. Hey, most of the time, don't. I'm gonna tell you, don't believe it. The people that you need to listen to is those people that's sitting in court with you right now. Okay. That's the people. That's the ones that have your back. They have your best interest at heart. Okay. I know you might not say. You might say, "Oh, they old. They don't know what they talking about." You're 22, right? Now I'm looking at who is that? That's your mom? Oh, okay, your grandmother and your aunt, right? Guess what? They're older than you, right? You 22? They spent the whole year being 22. Each one of them. They spent the whole year being 21. You haven't got to 23 yet. They spent the whole year being 23. Okay? So the point I'm trying to make to you is this. Where you are going, they've already been. There's nothing new under the sun. Okay? Guess what? Your hairstyle is not new. It's the style now, but it was the style years ago. That's the truth. There's nothing new under the sun. They've been there, done that. And I know when you hear it, you say, oh, they don't know what they're talking about. They done been there, done that. Okay? And people kind of behave the same. And so what they're trying to do, they're trying to help you. Okay? So that you'll have a brighter future. Now you're here today, right?
Yes, sir.
This is not your destination. Okay? Your situation is not your destination. Okay. And so what I'm saying is what you going through today is only a setback. But guess what? A setback is a setup for a comeback. Okay. And so you can leave here today and change your life. Okay. You can change your life. Okay? People tell you don't listen to people when they tell you can't do this or you can't do that. I don't care where you came from. You came from Port Arthur. You still could be on top of the world one day. Okay. So what I'm trying to do is just encourage you to listen to your family, watch the company you keep, and I guarantee you it'll turn your life around. All right.
Yes, sir.
All right. So she's going to give you a reset. Once you get your reset, you're free to go, and you have a blessed day. Did she give you that paper to fill out? Okay. Just have a seat at that table right there. Okay. Follow her directions. Cheyenne Buxton did not answer. A reasonable time has passed to give Ms. Buxton an opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Cheyenne Buxton bond will be forfeited and cause number 23 CCCR 1250. Next case is cause number M332540. Case is styled the state of Texas versus Corey Jamard Frank. Corey Frank was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Corey Frank at the courthouse door. Corey Frank did not answer. Corey Frank has not appeared in court since the court has been in session. The time now is 11:13 a.m. on today's date of March 19, 2024. Ms. Bailiff, would you please call the name of Corey Frank at the courthouse door?
Corey Frank.
Corey Frank name was just called the courthouse door. Corey Frank did not answer. A reasonable time has passed to give Mr. Frank an opportunity to appear in court. He is not appearing in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Now, Ms. Segura, I see we have lines. Was the lines already transferred?
Yes.
Okay. Next case is cause number 23CCCR 0414. Case is style of state of Texas versus Alan Martinez Marquez. Alan Martinez Marquez was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Alan Martinez Marquez. Alan Martinez Marquez did not answer. Alan Martinez Marquez has not appeared in court since the court has been in session. The time now is 11:15 a.m. on today's date. Ms. Bailiff, would you please call the name of Alan Martinez Marquez?
Yes, sir. Alan Martinez Marquez. Alan Martinez Marquez.
Alan Martinez Marquez name was just called again at the courthouse door. Alan Martinez Marquez did not answer. A reasonable time has passed to give Alan Martinez Marquez an opportunity to appear in court. It is not appearing in court. State, do you have a motion?
State moves for bond forfeiture.
That motion will be granted. Alan Martinez Marquez bond will be forfeited and warrant shall be issued for his arrest in cause number 23 CCCR 0414. Next two cases are cause number 23 CCCR 2388 and cause number 23 CCCR 2580. Both cases are styled the state of Texas versus Omar Gutierrez Sanchez. Omar Sanchez was scheduled to be in court this morning at 9 a.m. At or about 9 a.m. The court's bailiff called the name of Omar Sanchez at the courthouse door. Omar Sanchez did not answer. And Omar Sanchez has not appeared in court since the court has been in session. Ms. Bailiff, could you please call the name of Omar Gutierrez Sanchez at the courthouse door?
Yes, sir.
Judge, I'm showing that letter came back.
Omar
So that's not
Sanchez.
correct.
Oh, the letter came back. Okay, okay,
Yes, sir.
okay.
Yeah.
No response, Your Honor.
Okay, thank you. The court has just been informed that the letter that was sent out to Mr. Omar Gutierrez Sanchez came back undelivered. So at this time, the court will not be able to forfeit the bond. And this will conclude the calling of the court's Raymond docket on today's date of March 19th, 2024. And County Court at Law Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. State